Ladies and gentlemen, welcome back to the CONVO Couch. The other day we interviewed lawyer Michael Santucci in Florida about the Epstein case. However, we left one small part out. Here's Michael Santucci to fill you in on what he discovered.
Hi, Pasta, Fiorella, Johnny, and ConvoCast audience. This is attorney Michael Santucci in Florida, working late on Eastern Standard Time. I am a Florida and federal attorney, and I wanted to provide some notes to my prior interview and conversation with Pasta from the Convo Couch. As I mentioned before, I obtained a copy of, this is what it looks like, Jeffrey Epstein's motion to the court in the Southern District of New York federal case that was recently opened, asking for pretrial release, basically asking for a bond hearing and, to not have to be incarcerated while awaiting trial. And there is attached to it, now Epstein's own attorneys attached this to his motion to the judge. It's the non-prosecution agreement, or what people are referring to as the sweetheart deal or the plea deal. This is the non-prosecution agreement. This is what it looks like with the United States government and between the United States government and Jeffrey Epstein. It is attached, like I said, to a motion for pretrial release. In the Southern District of New York, they don't really file traditional motions. They file letter motions, so it looks like this. It looks like a letter to the judge from Epstein's attorneys. And he attached this non-prosecution agreement. So, I know a lot of people are frustrated that the whole story of the Epstein saga and crimes are not being told. People feel like the government is not telling the whole story. People suspect that there are powerful people that are trying to conceal some of these facts. And the Labor Department had no comment when asked about this. Why the Labor Department? Because the federal prosecutor in the 2007 case, who was accused of giving Epstein the sweetheart deal, Mr. Acosta, Alex Acosta, he was asked during an interview with the Trump transition team to get his job. He was asked about the Epstein case, and he is quoted in mainstream media as saying, "I was told Epstein belonged to intelligence and to leave it alone." And he told his interviewers in the Trump transition that he was told to back off, quote, been told to back off, and that Epstein was above his pay grade. Now, there's an Acosta letter involving that people want to know about and want to see, and so far, the Labor Department had no comment when asked about this. The Labor Department would have records, I would imagine, of the interviews that the Trump transition team undertook when deciding who to put in what positions. So perhaps a Freedom of Information Act request to the Labor Department would be one way to start. So my point in reviewing this non-prosecution agreement, it raises a question because in paragraph 13 or section 13 of the conditions of this non-prosecution agreement, or paragraph 13 of the plea deal, says the parties anticipate that this agreement will not be made part of any public record. That's akin to a confidentiality agreement. So both the government, the federal government, and Epstein are acknowledging that they do not anticipate this agreement being made part of the public record. Okay, if this is a confidentiality clause, then why is Epstein attaching it to his motion to the judge asking for pretrial release? Why is he disclosing it publicly? Why am I, attorney Michael Santucci, able to get this non-prosecution agreement, a copy of it, and I can read the whole thing? How come I can get it if this was supposed to be kept confidential? So that opens, begs the question, if the government wants to disclose other confidential facts involving this plea deal and involving that case, why can't the government rely on his breach this month of that confidentiality clause in his new case that was just filed in July of 2019? Why can't the government claim that he breached it? So we'd like to provide all the facts for the American people. Why couldn't the media bring some members of the media bring an action claiming that this confidentiality was breached? It shouldn't be breached selectively or cherry-picked, especially by a guy like Epstein. So the press and the American people should be able to hear everything. So I don't know if that is a breach. I don't know if the government allowed him to attach that. I don't know if he asked for permission. In the new 2019 case, I certainly don't see any request by Epstein's attorneys to disclose this supposedly confidential agreement. So I don't know that he did anything wrong by doing that. But if he did, then why can't everything be disclosed? Why cherry pick what he discloses? Why does he get to disclose only what he thinks gets him out of federal detention so he can roam the streets? So normally when any citizen or members of the media or people interested in government-held information want that information, they make a Freedom of Information Act request on that government agency. Google it. You can figure out how to do it. Go to a First Amendment attorney. Go to a media law attorney and ask. And then if that is denied or the government agency does not fully comply with it or doesn't adequately comply with the Freedom of Information Act, a lawsuit can be brought. So, and in such a lawsuit, I'm wondering whether this now, July 2019, publication and disclosure of what was supposed to be a confidential agreement could be the open door for our people to find out the whole story. Hypothesis. I'm Michael Santucci, Florida and federal attorney. That's what I've got so far. I'll continue to follow up on this. Convo out.
Remember to like, share, subscribe to the Convo Couch, YouTube, Facebook, and Twitter. And if it can help us out, check us out on our Patreon. See you then.